So right as we're approaching the finish line of this legislative session, the legislature amends Senate Bill 1127. That, of course, is the Glock Ban Bill, which bans firearms in the state of California that have the cruciform trigger bar, essentially taking hundreds of models of firearms off the shelf in the state without any committee or any talking about the actual amendments themselves. Is this unconstitutional? Let's talk about it. Hey everybody, welcome back to the channel today. The California State Legislature is moving toward its end for this year, but it is not done yet as we see more amendments added to Senate Bill 1127. That, of course, is the Glock Ban Bill. So to walk us through that today, we have brought back our legislative director. He is also the host of Firing Line Radio on AM 590 The Answer. You can catch him there every Saturday at 1 o'clock. That, of course, is Rick Travis. Rick, thank you for being on with us today.
Thank you for having me.
Absolutely. And guys, as always, please be sure to like, share, and subscribe to these videos. We're trying to get this information out to help people, and you can help get it out there by liking, sharing, and subscribing. So if you want to directly contribute to that, please go ahead and do that. It really does help out the channel. So Rick, let's just jump right into this. Kevin, if you could pull up the Legislative Digest here for 1127. And guys, I'm reading from the Legislative Digest because the actual bill is just referencing a bunch of other laws that are already that have already been voted on. They're just a bunch of numbers. So I thought it would be a little bit easier to read from the digest on these changes. And then, of course, we're going to ask Rick to dissect it for us a little bit. But the digest, it reads like this. Kevin, if you could pull it up. Existing law, subject to certain exemptions, generally makes it an offense to manufacture or sell unsafe handguns as defined and required by the Department of Justice to compile a roster listing of all handguns that have been tested and determined not to be unsafe handguns. Existing law establishes criteria for determining if a handgun is an unsafe handgun, including for firearms manufactured after a certain date and not already listed on the roster, the lack of a chamber load indicator, and a magazine disconnect mechanism. For any pistol listed on the roster on January 1st, 2026 that was not subject to the above described requirements to be on the list because it was submitted for testing before specified dates, that is thereafter only modified to change the design feature that brought the pistol within the definition of a machine gun convertible pistol, and that is submitted to an independent certified laboratory for testing pursuant to the above described testing provisions before January 1st, 2027. This bill would authorize that pistol to be submitted for testing and added to the roster without meeting those requirements. So I guess even the digest is a little bit difficult to digest here, Rick, and I'm hoping you can break it down for us. I mean, what it kind of seems like is you have firearms that are grandfathered into the roster that are now about to be made illegal to sell because of Senate Bill 1127. And even if you were to fix those firearms, they would then be subject to the things they're not subject to, given the Unsafe Handgun Act with its regulations. Am I getting this right? How can you break this down for us? This is a little bit confusing.
Well, it's still in flux, and we'll talk about that in a second. But look, this is specifically, as we've said all session long, going after the Glock Gen 3s here in California. So, when you look at the digest, which unfortunately in many cases is a lot of gobbledygook, because it's very confusing the way they write it. So when you ask me, does this say that, you're not grandfathered in? Well, yes and no. And nobody likes that answer, but that's the fact. This actually provides some opportunities for us possibly to get a later generation, like a Gen 5 Glock here in California, actually, after this is all said and done, which is part of the watering down process that's went through. I mean, we have pushed our point all session long of, hey, this could be simply fixed by removing Glock 3s and putting Glock 5s on. Now, I know some people are going to be like, why would you do that? Well, I'm trying to make sure that you can still get Glocks here in California. And there are a lot of people acting in this space, but let's be really clear. When you go back and it says for any pistol list on the roster or before, prior to January 1st, 2026, that was not subject to the above described requirements to be on the list because it was submitted for testing before specified states. Yeah, you're looking, and it can be converted to a machine gun, which is what they're saying. Then it would need to be retested, and if it was retested, it could be replaced back on the roster, showing that you corrected the problem. Um, you know, I don't know if anybody's going to want to pay for that retesting to go through all that process. What all of us would rather do is like, fine, if that's the issue, let me sell my Glock 3 to someplace else in the country and take that money and possibly a little bit extra and go buy a Glock 5 and be done with it. Like, I get to upgrade, have a better firearm with better safety features, all the way around better. So that is what's happening in that part of the bill, but there is more.
Well, I'm sort of curious because, you have different kinds of changes that can happen as we do read throughs on these. You have an amendment like this is going to take effect July of 2026 as opposed to January 2026. That seems pretty reasonable, but when you're thinking about the scrutiny that these bills have to go through, all of these committees where they're going through these bills, they're approving them or they're denying them. Is it common to have such a substantive amendment to a bill this late in the session where it doesn't have to go through the scrutiny of all of those committees?
No, and to be really forcefully blunt on this, a lot of times we get hung up on the minutia. And in this case, look, I'm a person that loves Glocks, so I'm just going to say that out there. I have Glocks, I have SIGs, I love those firearms. But we often in our community get hung up on one little thing and we miss the bigger picture. And the bigger picture is what you're alluding to. Kevin, like so many other things going on in our government just within this state, this again is a violation. The whole concept in moving a piece of legislation is it goes through, as you just clearly stated, multiple committees in both houses where people can testify on behalf or against, and we can go through this process of amending and looking at it. Once we get through both houses and it goes to the floor, your voice as an individual is essentially cut off. You no longer have representation. So now when they go to amend, they can put anything they want into these bills and you have no recourse. You have zero voice. And then they slam these through and say, well, what? We discussed them. Well, no, you didn't discuss them. That's like, there's not even a good analogy for this. It is just strictly unconstitutional and not right, but it doesn't stop them. We know this in California, that legislators, no matter how many times they're told by the Ninth Circuit, the Supreme Court, and the rest of the judicial system, no, no, and no, and no times 10, they go, well, what about this way? What about that? I mean, they just keep it up. If you go and, look at some of the things that they put on this crazy bill, I was talking to one of our attorneys about it, the definition, if you go and read through this bill, is one of the definitions of firearm component. DOJ has never defined what a firearm component is. The legislature doesn't have a definition of what a firearm component is. You can ask 10 people in our community, what's a firearm component? Going to get 10 different answers. There's no definition. We do not practice law, practice public policy without clear definitions. This is so loose that you can call anything a firearm component. And I don't know if it is. It's like they're also talking about reasonably designed or intended. Okay, well, what's a reasonable intent? That's not defined. And given the way the language is in this, given the watering down of this bill from the amount of pressure we've placed on it, there are some options where arguments could be made that you could remove one firearm from Glock off the roster and substitute it with another one. Just there are so many things. I mean, that the whole term reasonable is thrown throughout this whole thing, and reasonable is such a loaded term because what's reasonable for one person is not reasonable for another. Kevin?
I mean, I'm sure that this isn't the only bill. Well, we've discussed it, so of course this isn't the only bill where they use language like this. I don't think I've actually ever caught your thoughts on it, though. I mean, do you think that they continue to use language like this so that they can enforce the law however they see fit? Is it intentionally ambiguous that way? Are there any other benefits that you see, or is it just culture shaping?
Well, I would say culture shaking is the status quo in this state, and I don't think you would disagree. But to bring it down to more everyday terms that anybody can use as a talking point, look, we work in a state, we live in a state, we're trying our very best to thrive in a state which used to appreciate people's freedoms of choice. We claim we do, we don't. We used to live in a state where we upheld people's rights to their own opinions. We clearly don't anymore. Um, and when you look specifically at a bill like 1127 or a couple of the other ones that are on the floor right now trying to get passed through, there is no intelligence behind it, because common questions that I always ask in public policy is, okay, so why are we doing this? All right, so to hear Assemblymember Gabriel, it's because, well, there is the remote possibility that somebody could put a device on this firearm and turn it into a fully automatic firearm. Okay. How's that happened? Well, not that we can prove. Okay. What are the odds with the millions of those Glocks that are in this state? What are the odds? There's no answer. Is it not already illegal? Yes, been illegal to do anything remotely like that for decades. So there's already a federal law that if you were to be stupid and to do this act, you're going to jail for a long time and losing all your rights. Correct. So then again, why are we doing this? And it's simply to remove
Well,
firearm brand from it. It's a gun grab.
yeah, I was going to say it's pretty clear that it is just a gun grab. And we've been pretty vocal about that, which is why we've opposed this from the beginning. I'm sure same reason for all of you watching why you're opposing it as well. So, Rick, I mean, the lifespan or the length of the race now is extremely short. What are your final thoughts on these amendments? And I know that we've kind of already discussed this, but from here, what's the path forward from this, potentially even through the governor's desk and beyond that?
We're appealing to the governor's staff. We're appealing to the governor himself. We're saying that this isn't really bright. We're doing a lot of things. The effectiveness of that, it's hard to say. We've got a couple of bills around 2A arguments and stuff that it looks like he may veto. We don't know. There's others that looks like they're a slam dunk. This one and a couple others, I think, are not necessarily slam dunks, but they may squeak through. And if they do, then our lawyers stand ready to go ahead and file injunctions and fight back. I hope it doesn't come to that, but I also want to put out there, because I've seen some people get a little negative on some of this stuff. We fought literally against over 70 bills that were negative towards the Second Amendment and activities that we practice under our Second Amendment right. And we now stand in the final couple of days of the session before things go to the governor's desk with literally 5 bad bills that have went through. 3 that of those 5 are really egregious. The other 2 are bad. I'm not taking away that they're bad, but they're not going to harm that much of the community, and they're fairly easy to get overturned in a court. Those last 3, we can get them overturned. It's going to be a bigger fight, but compared to what we were facing, this has been a very good, successful year compared to the point that we've had seats flip in our direction. I just want people to realize that as upset and disappointed I am that we didn't stop these 5 as well dead in their tracks. This has been our best year in a long time, and I think people need to also understand that.
Yeah, 65 out of 70 battles won. And then if there's anything that we've learned, at least over a lengthy time period, but in the court system, it seems like we win the overall war there as well. So definitely good to see that percentage go up, but these 5 we will continue to follow. Rick, I know that it's crunch time for you this time of year. I want to thank you very much for coming on and sharing with us.
Thank you very much for having me. It's always a pleasure, Kevin.
Absolutely. And guys, if you like this content, you want to see more videos, you want to follow these litigative and legislative efforts that we have here in California, please be sure to like, share, and subscribe to the videos. It really helps get the information out, and it's a great way for you to directly contribute to these campaigns to keep the Second Amendment movement pushing in the right direction here in the state. So thanks again, guys. We'll see you on the next one.